Okay, welcome back. This is lecture number 4 in the Civil Rights Movement lecture series, and today I want to talk briefly, just have a few slides to talk about regarding the structure of the U.S. legal system. And the reason that it's important to put this particular information in your hands right now is because, as we've talked about in previous lectures, there were lots of techniques that were used after the Civil War to undermine the power and the newly freed rights of freedmen after the Civil War. But it's important that you understand how that was done. In any democratic government or any system, if you have structures in place, as we do in this country, to ensure people's rights, it doesn't matter how well constructed our Constitution is or how well constructed our government is. If people don't actually understand how it works, and if people are manipulating the systems that are supposed to be protecting people, then ultimately you can't have justice. And oppression relies upon denial of people having access to their rights. So in order for people to be oppressed, a system actually has to deny them access to the systems and structures and power that, even in a democratic society, we hope to guarantee people. So in order to understand how laws, for example, in the last lecture we talked about the Jim Crow laws and the Black Codes, how these laws got passed and how they were sustained in American history, the first thing I want to do is talk about this structure. And the graph that you have in front of you is a very basic flowchart structure of the American legal system. And what you'll notice is that the very top, the red bar at the top, the federal government, U.S. Constitution, federal law, and the Supreme Court, these are all the sort of post holes for the federal system. When the Constitution was written, it was written as a federal system, a system that would guide all states. And it would be the unifying system ultimately for all of those, and ultimately 50 states, what we have today. This is one of the things that was the basis of the Civil War, that those rebel states didn't want to ally themselves any longer with the federal rules and structures that were in place under the Lincoln administration. But once the Civil War was over and those rebel states were brought back into the U.S. government, it's important to understand that they were subject to all laws of the federal government, all rules, all elements of the Constitution. So in effect, the federal government and the federal courts act as the sort of top dog, the superior system in the U.S. And then underneath them are the state constitutions and state laws. Each state can pass their own constitution, can pass their own laws. However, it is subject to federal law. So there is federal review of all of these state laws. So for example, if you have a law that violates the federal constitution in some way, let's say a state, for example, decides that they are going to allow people to be tried twice for the same crime. You know, a state can pass that law. They can say, well, we've decided that, prosecutors can have 2 opportunities to try someone. Well, that would be a violation of federal law. And so the federal government, therefore, could come in and, in fact, require those states to comply with federal law. So the state laws are subject to the laws and rulings of the federal courts and the federal Constitution. In the same way, local ordinances, local laws, and local governments are subject both to state law and must comply with state law and federal law. So it's this multi-tiered system. So what is intended to happen is it's intended to be kind of a system with sort of checks, safety checks. So if the local ordinance is a violation of your rights under the state constitution, let's say that the state of Wisconsin, or rather the city of Lodi, decided that they were going to say that no hunting could happen anywhere in the county, let's say not even the city of the county, Columbia County was going to say no hunting anywhere in Columbia County. That would be a violation of Wisconsin law, and therefore Wisconsin could come in and actually change the rules in Columbia County or require Columbia County to change. But here is the catch. Just like with anything, just like with your parents, if your parents have a rule and they say, you have to be in by 12:30 curfew. That was my curfew, by the way. If you have a 12:30 curfew, that's great. That's that's law, so to speak, in your house. But if your parents don't enforce it, if you roll in at 12:45 one night, and the next night you roll in at 1 o'clock, and eventually over the course of time, you're going to end up rolling in at 3, 4 in the morning, right? I mean, depending on who you are and what you may or may not be doing at that time of day. But it's the same thing in like general law, formal law. If a government isn't willing to enforce those laws, then it's as if they don't exist. After the Civil War, the only president to enforce federal law and to say that groups like the Ku Klux Klan could not violate the rights of African Americans was the Grant administration. It was going to be 15 presidents. 15 presidents would come and go without any enforcement of federal law to protect the rights of African Americans. So, for example, in parts of the South where the black codes were being passed and Jim Crow laws were being passed, saying that black people had to pass literacy tests to vote, where black people were being lynched without a trial, so essentially being given no constitutional rights to a fair trial, no due process. Because the federal government did not intervene and did not require those states and those local areas to enforce their laws, it was as if the laws did not exist. And so we talked about the 13th, 14th, and 15th Amendments as these really powerful and important post-Civil War amendments. But because no one was enforcing them, it was as if they didn't exist. One of the major things that began happening after the Civil War, as I mentioned previously, is the Black Codes. And the Black Codes and the Jim Crow laws, which are distinct from each other in some ways, but oftentimes when I talk about them, I'll talk about them together. But these Black Codes oftentimes established sort of separations. And the Jim Crow laws also, the Jim Crow standards, created what was called a segregationist structure or system. So they separated out areas and systems. They said, for example, in baseball stadiums, remember we're talking about a time when there was no television. And so people went to baseball games. It was a very, the great American sport. It was a very popular thing to do. But if you went to a baseball game and you were an African American, any time after the Civil War, all the way up through really the 1960s and into the early 1970s, you could be guaranteed that you would be sitting in a separate section of the stadium. And this segregation, this separation based on race, was found everywhere throughout America, even in Madison, Wisconsin. Even by the early 1960s, the city of Madison had segregationist policies and ordinances in place. So this is an example where a local ordinance said that you would have separate, for example, in the city of Madison, separate drinking fountains. Well, to have those separate drinking fountains is arguably unconstitutional, because it's not an equal application of the law. You're not equally protecting people. But unfortunately, people still held to these rules because the federal government did not come in and require them to actually follow the 14th Amendment. But also, immediately following the Civil War, in the late 1800s, a case came before the U.S. Supreme Court that not only dealt with these issues of segregation, but actually supported notions of segregation. The case was called Plessy versus Ferguson. And the slide you're looking at right now kind of reviews some of those, the 13th through the 18th Amendments, those post-Civil War amendments. We haven't talked about Amendment 16, 17, and 18, but they're often considered part of the Civil War amendments as well. And moral structures in the South were being confronted. People were having their buttons pushed, and it was very upsetting. But there were blacks who wanted to confront these black codes, some of these segregationist policies. And the case of Plessy versus Ferguson was about segregation in public transportation. A middle-class black man, in this case, the scenario was like this, purchased a train ticket, a first-class train ticket, wanted a nice seat on a nice train, purchased a ticket. When the conductor came through, the conductor asked him for his, or told him, get out of this section. This is a whites-only section. The first-class car on this train was a whites-only train. The ticket holder replied, "Hey, I've got a ticket. I've purchased this first-class ticket. It was more expensive. This is where my ticket says I'm supposed to sit. You can't force me to move." And in fact, the train conductor actually forced him to move, and this passenger sued the train company, saying that it had violated his equal protection rights, the 14th Amendment's equal protection rights, by denying him access to the first-class train that he had purchased a ticket for. So this case goes before the U.S. Supreme Court. So it went through the state courts, it went all the way up. That's how the courts work. You can appeal your way up. And the Supreme Court is the highest law in the land. And the court looked in 1896 at this case and looked at the 14th Amendment. And in one of the most devastating and probably infamous and tragic decisions of any U.S. Supreme Court, they made the decision to uphold the right of governments, of organizations, of companies to segregate all facilities. And what they said was that you could have separate facilities as long as they were equal. So they came up with this theory of separate but equal. And the Plessy versus Ferguson ruling, which established this separate but equal policy, was what justified the separation of drinking fountains, the separation of restaurants, the separation of bathrooms, the separation of schools. And so setting up after 1896 all the way up through the mid-1950s, we have structures being put in place that are dramatically separating blacks and whites in all aspects of life. And now it's legal to separate people like this. And it's because of the Plessy verdict. The next slide I'm going to show you, you shouldn't be surprised to know that these white Southern men, of the gentlemen that you see here, the Supreme Court has 9 justices, 7 were from Southern states. And they're all white men. And it shouldn't surprise us that this court, the 1896 court, makes this decision. So this sets up the segregation and the segregationist practices. And that essentially is Plessy's contribution to the civil rights era. But as we're going to find out later, the courts will deal, this issue is not done, and the courts will continue to have to deal with this issue in the coming century. So, okay, that's the summary there. Thank you.